This is Revelations.Unveiled. Detroit. Family, you ever wonder why police can pull you over, shake you down, stop and frisk you, take your property, seize it, forfeit it, break into your home, kick down the doors, destroy all your property? How you can be manhandled, physically abused, and traumatized by the police with no repercussion. How is it that the police, the cops, the sheriffs, the agency of enforcement in the states and municipalities across America, how can they brutalize the citizens of the society? How can they kill and not be held responsible? How is it that they can have long records of complaints and several lawsuits against them? How is it that the policing unions and the fraternal orders and the fraternal organizations and brotherhoods of these police officers never endure the stigma or the suffering of the brutality and trauma and treason they impose upon the populace of America? Well, in this series, or the second part of this series, Fuck the Police, we will get more clarity on this tool, on this legal precedent, on this legal doctrine that these police rely on when they commit these wicked acts against the citizens. This qualified immunity doctrine, which gives them all rights to commit perverse acts against the people. So we'll be reviewing an article from Reuters as it pertains to qualified immunity and the Supreme Court's leverage of the policing powers. And we began. The justices reversed a lower court decision and granted immunity to Texas State Trooper Chandran Mullenix, who had stopped a high-speed chase by shooting at a vehicle from an overpass, killing the driver. Critics of qualified immunity say the High Court's guidance has created a ludicrously narrow standard. Even some judges feel constrained. In a 2018 decision, James Browning, a judge in federal district court in New Mexico, said he was ruling with reluctance in favor of an officer who had slammed an unarmed man to the floor in his own home while he was yelling at police. The force the cop used, Browning ruled, was excessive, but the officer had to be granted immunity, he said, because the subtle differences with the earlier case Browning had considered as a possible clearly established precedent. Those differences included the distance between the man and the officers and what the men were yelling. Even locations of the respective incidents could be a factor, the judge noted. The earlier case having occurred in a Target parking lot. So basically, family, what's the clearly established law in or framework is, whatever the case is being weighed, whatever the precedent law established is, that case must fit into that framework perfectly. So, time, date, number of parties, etc., everything must fit perfectly in the quote unquote clearly established precedent. In his ruling, Browning criticized the High Court's approach because a court can almost always manufacture a factual distinction between the case it's reviewing and an earlier case. In February, the Federal Appeals Court in Cincinnati, Ohio, granted immunity to an officer who shot and wounded a 14-year-old boy in the shoulder after the boy dropped a BB gun and raised his hands. The court rejected as a precedent a 2011 case in which an officer shot and killed a man as he began lowering a shotgun. The difference between the incidents was too great, the court determined, because the boy had first drawn the BB gun from his waistband before dropping it. In other recent cases, courts have sided with the police because of the difference between subduing a woman for walking away from an officer and subduing a woman for refusing to end a phone call. The difference between shooting at a dog and instead hitting a child and shooting at a truck and hitting a passenger, and between unleashing a police dog to bite a motionless suspect in a bushy ravine versus unleashing a police dog to bite a compliant suspect in a canal in the woods. The Supreme Court in 2009 raised the bar even higher for plaintiffs to overcome qualified immunity. In Pearson versus Callahan, it gave judges the option to simply ignore the question of whether a cop used excessive force and instead focus solely on whether the conduct was clearly established as unlawful. In the decades since then, the Reuters analysis found an appeals court has increasingly ignored the question of excessive force. In such cases, when the court declines to establish whether police use excessive force in violation of the Fourth Amendment, it avoids setting a clearly established precedent for future cases, even for the most egregious acts of police violence. In effect, the same conduct can repeatedly go unpunished. The case of Kari Illich shows this perverse dynamic at work. One cool spring evening in 2013, sheriff's deputies in Phoenix City, Alabama, a suburb of Columbus, Georgia, responded to a trespassing call. They found Illich wandering along a quiet, tree-lined road. The 25-year-old was naked, covered in scratches, and behaving erratically. In the encounter, the deputies shot Illich 6 times with a stun gun before he fell to the ground. As he lay face down, one deputy shocked him 13 more times as 2 others struggled to handcuff his wrists, according to their testimony. They then shackled his ankles with leg irons and fastened them to his handcuffs, an extreme form of restraint known as a hog tie, that many police departments across the country have banned. A 385-pound officer then kneeled on Illich's upper back until he went limp. Illich was pronounced dead on arrival at the hospital. The autopsy report lists cardiac arrest as the cause of death. They treated him like an animal, Gladys Callwood, Illich's mother, said, or maybe even worse. Miss Callwood sued the police alleging excessive force. The cops claimed qualified immunity. They said they did what was necessary to subdue an aggressive man who resisted arrest and who, according to a friend who had seen him earlier, had probably taken LSD. A toxicology report found no traces of the drug in his blood. So family, you see how they make these statements against the character of the victims, even when they find no evidence of that statement? You have to make split-second decisions. Ray Smith, one of the deputies who had shot and hogtied Illich, told Reuters. Hesitation can be deadly, he said. Judge W. Harold Albritton in federal district court in Montgomery, Alabama, sided with the cops. In his ruling, the judge said there was no precedent establishing that the officer's treatment of Illich was unlawful. Wow, so wait a minute, let's see. He gets shot 13 times first, and then he falls down, and when he's laying down, he gets shot 13 more times. Then he's handcuffed and shackled at the ankles. Then an almost 400-pound officer kneels down on his back, and they don't regard that, family, as unlawful. All right. The Atlanta-based 11th U.S. Circuit Court of Appeals agreed. Even though it had heard a case involving hog tying in Florida in 2009. In that case, Donald George Lewis died after West Palm Beach cops hog-tied him on the side of the road where they had found him disoriented and stumbling through traffic. But the appeals court in that earlier case granted immunity without addressing whether the force police used was excessive. As a result, the court didn't establish a precedent that could apply in subsequent cases, including Callwood's. By allowing judges to consider only the question of clearly established law in excessive force cases, the Supreme Court created a closed loop in which the case law gets frozen, said lawyer Matt Farmer, who represented the Lewis family. In October 2018, the Supreme Court declined to review Callwood's case. Her lawsuit, like Miss Adalba's, was dead.